Thank you, Mr. Hebner, and counsel, thank you for joining Judge Bennett, Judge McBrayer, and me for this argument this afternoon. Please understand that your argument, our hearing, is being broadcast by live streaming as we speak, and it will be posted on the Administrative Office of the Court's website for viewing at a later date that whenever anyone needs to observe this argument. We will conduct the argument as in the same fashion as if all of us were in the courtroom together. Each side has 15 minutes, and of course the appellant has the right to and has reserved time for rebuttal. Unless there's announcements or other matters, we will ask Mr. Hebner to call the case.
Christa Lambert Karr et al. Versus St. Thomas Midtown Hospital et al.
All right, Mr. Bilbo, the floor is yours.
Please, the court, Your Honor. I'm Jim Bilbo, and my office is in Cleveland, Bradley County, Tennessee, and I represent the plaintiffs, Christa Karr and Jack Karr, in this healthcare liability case. Back in 2016, because of ongoing back problems, Mrs. Karr went to Nashville orthopedic surgeon David McCord, who first diagnosed her with scoliosis of the spine, ordered an MRI. Thereafter, he performed or ordered some injections, some other diagnostic testing, and ultimately he recommended surgery, which was performed at the defendant St. Thomas facility by Dr. McCord on July the 6th, 2016. After the surgery, Mrs. Karr continued to have problems with her spine, and ultimately she learned from an x-ray study on October the 31st, 2017, that there were some malpositioned screws. One of the screws was actually it had extended into her spinal canal, and other screws extended through her ribs and abutted her aorta. Based on that, we began considering a healthcare liability case against Dr. McCord. Well, later on, Mrs. Karr, because of ongoing problems, ended up with a neurosurgeon at the University of Cincinnati, who as late as 2015 had been at Vanderbilt Medical School. And he removed the hardware and did an exploration. And on May the 14th, 2018, the complaint alleges that for the first time it was discovered that the surgery was essentially unnecessary that was performed by Dr. McCord. And specifically, the degree of scoliosis was not severe enough to warrant a fusion surgery. And in addition, another thing was that one of the post-surgery diagnoses was a herniated disc, and the surgery didn't even include a decompression, which is the treatment that you do for a herniated disc. On March 4th, 2019, well, I guess I should back up just a little bit, not past too many things. And based on a potential cause of action against Dr. McCord for misplaced screws, malpositioned screws, notice letters were sent to Dr. McCord and to his business on October the 30th, 2018. On February 27, 2019, a complaint was filed against Dr. McCord and his business. On March the 4th, 2019, notice letters were sent to the St. Thomas defendants. And on July the 1st, 2019, the complaint was filed against the St. Thomas defendants. The complaint alleges, and it put the emphasis and quoted in our briefs substantial portions from the complaint, alleges that it was discovered on May the 14th, 2018, that the surgery was unnecessary. Notice letters as required by TCA section 2926 121C were sent within 1 year after the alleged discovery. The discovery that the surgery was unnecessary, because essentially you're looking at two different causes of action, if you will, one for malpositioned screws, which may or may not constitute a healthcare liability case, but also unnecessary surgery. The unnecessary surgery wasn't discovered, according to the complaint, as alleged in the complaint, until May 14, 2018. Within 1 year after that, notice letters were sent to the St. Thomas defendants, and then a complaint was filed within the 120 days after that for the extension of the statute of limitations. And so what we're relying on is, and of course, this case was dismissed on a motion to dismiss. It wasn't a motion for summary judgment. There hasn't been any discovery that has been taken. All we have are the pleadings, the complaint, and the answer, maybe some written discovery, if I'm not mistaken. I hope I'm not mistaken when I say that. Mr. Gorman will correct me if I'm wrong about that. But Tennessee Code Annotated Section 2926-116 says that the period of limitation shall be 1 year from the discovery date. That's part A2 of 2926-116. That shall be 1 year from the discovery date. And since the discovery date was May 14, 2018, according to the allegations of the complaint was timely filed. The cause of action against the St. Thomas defendants is based on what I refer to as a Barks allegation. Barks was the case, Barks versus River Park Hospital, Inc., 328 Southwest 3rd, 829, that says that a complaint may be possible based on the facts, may be proper against a hospital for failure to formulate and enforce policies and procedures. And specifically in our complaint against the St. Thomas defendants, we allege that St. Thomas was, and I'm paraphrasing, but St. Thomas failed to formulate and or enforce policies and procedures to prevent patients from undergoing unnecessary surgeries. And that was unknown until until Dr. Ching took the hardware out on May the 14th, 2018. And so finally, I will just say that in reviewing a motion to dismiss, the factual allegations of the complaint are presumed to be true. And assuming that the factual allegations in the complaint are presumed to be true, I believe that the motion to dismiss, and argued this during the argument, it was premature. The facts need to be developed a little bit more to determine whether or not a dismissal is appropriate.
Did the complaint also include the factual allegations regarding the earlier discovery of the malpositioned screws?
I believe so.
Okay.
And we did include agency type allegations.
To what extent, Mr. Bilbo, does the concept of a plaintiff has knowledge and or a cause of action accrues when the plaintiff knows that they have or may have sustained an injury, and they don't need to know the extent of the injury or all of the consequences? How does that come into play?
I think it comes into play on the cause of action aspect of it, as opposed to knowledge or information that there may be an injury. I think it's based on the cause of action, and the cause of action for unnecessary surgery wasn't discovered until Dr. Ching removed the hardware. And there's some case law pretty much on point with that, I believe. Plaintiff is deemed to have discovered the right of action when the plaintiff becomes aware of facts sufficient to put a reasonable person on notice that he or she has suffered an injury as a result of the defendant's wrongful conduct. But the first sentence that I didn't read talks about right of action and not just the injury. So yeah, she knew that she and Mr. Karr believed that they may have a healthcare liability case based on the malpositioned screws, but they didn't know about the unnecessary surgery until later.
All right, thank you. All right, we will now hear from Mr. Gorman.
Good afternoon, Your Honors. May it please the court, Nate Gorman here in Nashville, Tennessee, on behalf of the defendants/appellees. This case was dismissed on a motion to dismiss that we previously filed. As we filed a motion to dismiss, it deals with the legal sufficiency of the complaint, the allegations therein. I think it's very important to note in this case the allegation, the specific allegation that began and the paragraph 25 open.
Mr. Gorman, I'm unable to hear.
On July 6, 2016.
Mr. Gorman.
Am I breaking up or are you unable to?
You're breaking up, and I'm unable to comprehend what you're saying.
Okay. Speaking now, am I still frozen or breaking up?
You sound good now.
Okay. Well, maybe I'll try and go a little bit slower and hopefully I won't break up again. I think where I probably left off or where I started breaking up is discussing this is a motion to dismiss, and it deals with the legal sufficiency of the complaint. As it deals with the legal sufficiency of the complaint, a statute of limitations defense is an appropriate defense to raise on a motion to dismiss. But one of the important parts of a motion to dismiss and of the legal review is that the court's not required to accept as true legal conclusions that are pled in the complaint. Our position is that to some extent, it actually, either way, if it is a legal conclusion on the date of discovery, it's not required to be accepted as true. However, even if that is a factual allegation that would be required to be taken as true, the plaintiffs pled at paragraph 23 of their complaint in this case, and I specifically say this case because there is another complaint that was filed as far as Dr. McCord's actions, but they plead that after her surgery, after Mrs. Karr's surgery on July 6, 2016, Mrs. Karr continued to attend post-operative appointments with Dr. McCord through October 31st, 2017. On that date, for the first time, Mrs. Karr discovered that Dr. McCord had malpositioned screws during the fusion surgery. She never returned to Dr. McCord. As that allegation reads, Mrs. Karr was aware that she had an injury, which was the injury that her surgery did not fix and that she was injured. And she also was aware of the identity of one of the persons who was involved in the surgery that they caused that injury. Those are the two elements required in order for the discovery rule to begin the statute of limitations running. The discovery rule doesn't allow a plaintiff to plead different dates of discovery for different causes of action. It is simply, it's an objective standard, and it wants to know whether or not they are aware of sufficient facts to place them on the need to investigate this injury further. It doesn't allow you to say, well, this is the cause of action. I've discovered a cause of action for medical malpractice. Oh, I've discovered a different cause of action that's related to this same injury. The injury starts the statute of limitations running for all causes of action. And specifically, there's some law, and it's the Vandergrift case, which is out of the East, a reported case out of the Eastern District Court of Appeals, that specifically states that it doesn't matter about whether the plaintiff is aware of a breach of a legal duty or whether or not the plaintiff is aware that they have a specific cause of action. It is just simply the discovery of the injury and of the and of sufficient facts to place them on notice of the identities of the individuals. This is not a case where they need to actually have actual knowledge. However, in this case, it is our position that they did have actual knowledge. Plaintiffs were aware that the screws had been malpositioned, and they were aware of the identities of the people involved in the surgery. That's sufficient to begin the running of the statute of limitations. And
how do you distinguish the Barks case that Mr. Bilbo relies on?
Your Honor, my understanding is that the Barks case is a more general case that deals with whether or not a cause of action can be maintained against a hospital for what I would call direct negligence claims. Failure to enforce policies and procedures, I think, was the issue in that case. And as I recall it correctly, it involved a policy and procedure that a hospital, I believe in McMinnville, had, where they required that every person that came into their emergency room be seen by a medical doctor and not just a physician extender, such as a physician's assistant or a nurse practitioner.
The gentleman was released and went home and died of a heart attack that night. But how do you distinguish it?
Well, I distinguish it, Your Honor, is that I don't believe that the discovery rule is ever implicated there. I think, if I understand the argument, is that it is, as far as it's distinguishable, it deals just with whether or not a cause of action may be maintained directly against a hospital for an action that the hospital took, as opposed to a vicarious liability claim based on one of its agents or employees. And so it's correct that, plaintiff can maintain a cause of action against the hospital, but as far as the discovery rule, whether or not they discovered their injury, I don't believe it's applicable. It's just whether or not they can maintain a direct liability action, Your Honor.
All right. Thank you.
Sorry, I took a while to get around to that.
In the earlier suit where Dr. McCord was sued along with his practice, was St. Thomas included as a defendant in that action as well?
No, Your Honor.
Okay.
So in that action, there was pre-suit notice was sent on October 30th, 2018, but it was only sent to Dr. McCord, his practice group, and I believe Northcrest Hospital. I'm not sure why, but St. Thomas was never included in that. And so, just the fact of the matter that there was pre-suit notice sent a day prior to the initial discovery date, I think that is further support that plaintiffs were on notice or had discovered sufficient facts to begin the running of the statute of limitations. Why else would there be any kind of investigation going on or sending pre-suit notice? And as far as, because it's a motion to dismiss, the prior suit can still be considered, and I believe it's still an ongoing suit right now, but it can still be considered pursuant to judicial notice and pursuant to the exhibits that are attached there to the prior suit under Tennessee Rule of Civil Procedure 10.03. But this case doesn't actually, in order to determine whether or not plaintiffs had knowledge of sufficient facts to begin, through application of the discovery rule, to begin the statute of limitations, it doesn't actually require any reference or review of the prior suit, and I say prior suit, it's still ongoing, but to the other suit, because plaintiffs have pled a date of discovery of October 31st, 2017 in this case. The second date of discovery, which they've attempted to plead, says at paragraph 27 of this complaint, says on May 14th, 2018, the first time, an additional discovery was made by Mrs. Karr. Well, you don't get to have additional discoveries for a different cause of action. It's just, did you discover do you have a knowledge of sufficient facts that you are aware of an injury and aware of the identity? And it's not even actual knowledge. It's just simple inquiry notice, which places them on a reasonable person would be aware of sufficient facts to actually go and investigate. That's our position, is that the statute of limitations runs for all the claims that they could possibly bring based on the date of discovery of October 31st, 2017. No pre-suit notice was sent to St. Thomas Midtown Hospital or St. Thomas Health before October 31st, 2018, which is 1 year later. Therefore, plaintiff's claims were not extended and they're barred by the statute of limitations. And unless anybody has any other questions, I will yield the floor.
All right. Thank you, Mr. Gorman. Mr. Bilbo, your rebuttal.
Your Honor, it's our position that Mr. and Mrs. Karr didn't know that they had a potential Barks cause of action until May 14, 2018. And there is the case law. The law is that actually knowing that one has an injury. Excuse me. Let me read it because I'll say it wrong. It's well settled that the discovery rule does not toll the statute of limitations until the plaintiff actually knows that he or she has a cause of action. The plaintiff is deemed to have discovered the right of action when the plaintiff becomes aware of facts sufficient to put a reasonable person on notice that he or she has suffered an injury as a result of the defendant's wrongful conduct. We're not talking about Dr. McCord's wrongful conduct. We're talking about the St. Thomas defendant's wrongful conduct for not putting into place proper policies, not enforcing proper policies and procedures to keep a doctor from performing unnecessary surgeries. And so that's the basis of the complaint essentially against the St. Thomas defendants. Those what I'm reading from is Pero's, P-E-R-O''S, 90 Southwest 3rd at 621, which is quoting Teeters, T-E-E-T-E-R-S versus Curry, 518 Southwest 2nd, 512 at 515. So it's our position that the cause of action wasn't discovered until cause of action based on unnecessary surgery wasn't discovered until Dr. Ching removed the hardware, May 14, 2018, and everything was done timely according to the discovery rule after that point.
And is it correct that this lawsuit, as distinguished from the first one against Dr. McCord and others, is limited to St. Thomas Midtown Hospital, doing business as Baptist Hospital, St. Thomas Health, etc.? That entity is the sole defendant?
Yes, Your Honor, it is. And the other, Mr. Gorman is correct, the other complaint, the first complaint filed based on expert review and all of the requirements prior to filing suit or simply against Dr. McCord and his business. And we didn't have didn't have the expert review and certificate of expert review and all of the things required in order to proceed at that time. But when we did, we proceeded.
Very good. Anything further, Mr. Bilbo?
No, Your Honor.
All right. Well, thank you both for your arguments, and we will take this matter under advisement. Mr. Hibner.
This honorable court is now in recess until